Aye.
Vote aye.
Vote aye.
Motion carries 8-0.
Okay, thank you. Next, we have CB 84, 2006, an ordinance concerning Chesapeake Bay critical area for the purpose of amending the restriction on growth allocations approved in the Resource Conservation Overlay Zone to conform the County Chesapeake Bay Critical Area Program to requirements of Chesapeake Bay Critical Area Commission. CB 84, 2006 was introduced by Councilmember Knotts on October 10, 2006. This was formerly known as CB 64, 2006. Madam Clerk, let's see, we have Mr. Tom Howler.
Good morning, Mr. Chairman, members of the council. Thomas Hallerman, attorney with offices in Lanham, and I'm here today testifying in support of CB 84, 2006, which is a bill, as you indicated, that would amend a single provision of the zoning ordinance related to the Chesapeake Bay critical area. Currently, the zoning ordinance provides that an area of waterfront property within 300 feet of the water can't be rezoned from the overlay zone in which it was originally placed, and it must stay in that current zoning category for the purpose of creating a 300-foot buffer. In the past, when the county has wanted to create a waterfront lot, it has, while it could not zone the area, it requested a growth allocation in order to allow it to do that. The Chesapeake Bay Critical Area Commission has recently ruled that such a practice is in conflict with state law, and they now take the position that whatever area of growth allocation you request must equal the area of property that you zoned. This bill would change the law to simply implement the Chesapeake Bay Critical Area's ruling to allow you to zone the area that you choose to allocate. In the future, then, if this amendment is adopted and the county desires to create waterfront lots, you would be able to do that consistent with state law. So as revised, this bill still provides for a 300-foot setback of structures to preserve the 300-foot buffer, but it simply gives you the ability to do in the future what you have done in the past. Thank you very much.
But Mr. Howler, I mean, isn't the situation that what this council actually approved would have been approved by the Chesapeake Bay Area Commission as it was approved?
The Chesapeake Bay Critical Area Commission did not approve
When this council voted not to have lots, if we had kept that decision and not had lots to the water, we wouldn't have this issue. And what I see, because I know some of my colleagues have raised concern about putting conservation areas within lots because they're often confusing to the homeowners who don't respect the conservation area. So the way I read this bill is you're attempting to create a situation that could lead to a lot of implementation issues. And if we had actually sent to the Critical Area Commission the decision that we voted on, we wouldn't have this issue, and the Critical Area Commission would have accepted it.
I think, Mr. Dernoga, that the determination of how you want each waterfront property to exist, whether you want it to have waterfront lots, whether you want the property to be in the in common area or whatever, is a case-by-case decision. And at this particular point in time, your hands are tied in that you can't do certain things. This simply gives you the flexibility in the future to do something that you've done in the past, which is to create waterfront lots that do have lot lines running to them. If you choose not to in the future do that, then that would be your prerogative, but it would be done on a case-by-case basis. This simply gives you the authority to do what you thought you could do before the Chesapeake Bay Critical Area made its ruling.
I'll turn to our staff attorney, Ms. Addis, who has a comment.
Yeah, in my conversations and review of state law, the state's concern is they don't want RCO less than 20 acres. So the legislation proposed that you're considering today will fix that. We won't have small pieces of RCO. Resource conservation.
Right. If we want to have lots that go to the water, irrespective.
Actually, their concern is if we're going to have the development, that if we're going to leave resource conservation zone, that it has to be a minimum of 20 acres. So in a scenario where you have a development that the total acreage is actually less than the 20 acres, you either would elect not to develop it and leave it in the resource conservation zone, or if you elect to develop it, you develop the entire parcel and take take the growth allocation for the entire parcel and use the setbacks proposed by this legislation. This legislation does provide the 300-foot setbacks. It doesn't provide a buffer, it provides a setback.
Right, so that they will be in lots. And
That's correct,
and
but-
subject to the whims of the owner, but subject to penalty if anyone ever notices.
That's correct, but the state policy is they don't want parcels less than 20 acres remaining in the resource conservation zone, because the policy now is that parcels less than 20 acres can't provide adequate buffer. That's the position they're taking, the state's taking. So you have to have a minimum of 20 acres or more to provide the adequate buffer the state's looking for. Otherwise, you need to take it out of the resource conservation zone.
Any additional questions of Mr. Howler? Thank you. Next, we have Sarah Cavett.
Good morning, Mr. Chairman, members of the County Council. My name is Sarah Cavett, and I'm here representing the Indian Head Highway Area Action Council. And now I'm totally confused. However, we oppose the bill. We are going to oppose this bill because I don't care how big the parcel is. I want a buffer. And I want a buffer that is enforced. My concern is, if we do this, we are going to have developers then who come in and ask to have it rezoned into the homeowner's lot, and there is no buffer, and there is no enforcement. We already have problems with waterfront lots where the buffer is not being enforced when it was supposed to be. And we have another parcel that's coming up for subdivision and for a preliminary plan on the which is going to be a 4 acres RCO, which means, okay, we can develop that too, and there is no buffer. So no, if there is no buffer, then we are opposed. If it isn't going to be enforced, is my other concern with the Critical Bay area issues. We are not having enforcement, and that was even one of the discussions that was held at the time of the Critical Bay Commission hearing that was held here. But we want a buffer, and we want it inviolable, period. And I don't know what the law has to be to do that. But that is what we want. Thank you very much.
Thank you. Dawn Davitt.
Good morning, Chairman, council members. My name is Dawn Davitt. I live on Shore Drive in Fort Washington. I'm here today as president of Potomac Valley Citizens Association. We too are in objection to CB 84, and we must say that so many people who were in objection to 64 continue to be in objection to 84. Most of us do not understand exactly what was happening. We thought 64 was tabled, had some respite until 07, and suddenly 84 appears. We feel not only Potomac Valley, but other groups that I have spoken with, the Sierra Club, the River Keepers, that we have not had adequate time to review. Regis Floyd has been very helpful in trying to get a tape for us, but I don't believe it was available until today, and consequently of a previous hearing that we feel is very relative to this, and consequently our attorney nor any of the others have had opportunity to know exactly what this means. I have talked with Lisa Herger, a staff at the critical area, and she wanted to run it by her attorney, was to get back with me, but has not. Our attorney has not been available, but says that we do feel the council should not be writing changes to the critical area law that are designated to benefit one property, which basically this will end up doing. It's a watered-down concept of the critical area law and is more general than specific. It does not address the concerns of the Critical Area Commission of their staff report of April 5th, which you'll be getting copies of from the next person coming up. They did not say some of these things in their conclusions. They had a main concern that there is no stewardship of the 300-foot buffer. They say to ensure consistency of the commission's conditions with the development review process of Prince George's County, the commission authorizes the Assistant Attorney General to coordinate the development and recordation of planting management plan and conservation easement with the county's process. They want that 100-foot area to remain RCO, be approved to have no development activities, including impervious surface, hardened surface, wooden walkways, no active recreation. You'll get all of this to read. So this law does not at all address that. I ask that this law be tabled, please, or voted down until those people, including the Historic Preservation Commission, who would like to go on record, and I believe you got a letter from the Historical and Cultural Trust in opposition, because most of the artifacts are found in the 300-foot buffer. We're either going to enforce the critical area law, uphold it, and protect it, or not.
Thank you, Ms. Davitt.
I'm sorry,
One
I know
question-
my mouth.
One question, very technical. You have the Historical and Cultural Trust letter. I think that was emailed to us. Have you submitted that into the record?
Oh, no, gee,
Ms. Lloyd, did you get a copy of that from the sender? You did?
the Cultural and Historic Trust? Okay.
I think it went to, it's addressed to the clerk of the council in the email, so if you could just provide that to Ms. Floyd so she'll have it.
Okay, this one is to Tom Denoga and,
And the email was to the clerk of the council.
oh, okay, fine. I will give you my copy.
Okay, and next we have Weldon Merritt. I'm trying to, I'm running here.
Hello, my name is Weldon Merritt. I live directly on the water at 12211 Riverview Road, adjacent to some of the properties here in question. And I had a little point of order. May I have your name, please? I didn't catch it. Okay, thank you. I have submitted some photographs which show what happens when the critical area law is not enforced. I would also like to note that the critical area law does not concern 100 feet or 300 feet. It concerns 1,000 feet back. And there are issues of enforcement of that that are of great concern to us. I find myself in a very conflicting situation at the moment, because the way the discussion seems to be going might mean that this legislation would be tabled, but I still have a duty, and that duty is to do what I can to ensure due process. And I would like to file complaints about members of the county council on ethics code violations concerning CB 64 and CB 84. I have done a lot of research, and I have discovered that the Board of Ethics for Prince George's County does not have a quorum. Their terms of office have all expired years ago. One of the members still serving has been there since 1997, and it is not possible for me to file ethics code violations with the county Board of Ethics. My mother, at the moment, is, however, filing ethics code violations, complaints with the Board of Ethics for whatever good that does. And I hope she will finish her work and that she will be able to come here to speak.
Okay, thank you.
Any
Anything
questions?
else? One quick question to staff. Is that correct that our Board of Ethics is due for updating?
I believe there are a number of boards and commissions that are continuing to serve that have not been reappointed. I don't know specifically about that one, but there are many that have continued to serve.
There was an annual report from the 21st of February, 2006, from the Ethics Commission asking to be relieved. This report was covered with a letter addressed to Messrs. Jack Johnson and Tom Dernoga. This letter from the 26th of February, 2006, has not, to this day, been answered. Thank you.
And I would suggest to you that we get those appointments from the county exec's office. We do not initiate them. So I think the point's well taken, and hopefully we will have some discussion about that.
I have. They're over there.
Okay, thank you.
You're welcome.
Is there anybody else signed up to speak? Okay. Seeing none, I'll declare the public hearing to have been held. Pleasure of the council.
Me?
Well.
If I'm the council, I've listened. And there are some issues that I think would require some more discussion. We do have time beyond today. What I heard just a few seconds ago wasn't necessary, but it was stated. In cooperation, where I feel that the public's interest is always important, being that a couple of individuals did raise some salient points as it relates to this particular matter as far as the legal issue on this. I'm going to ask my colleagues to hold it. We have until we would do it November the 14th or the 28th. I would ask that all parties discuss this, and something will happen within the next 2 meeting periods. But we have an opportunity to hold this today, all right?
And let me defer to our legislative officer.
Yes, no, maybe so?
I think we have to determine whether this is a land use bill subject to Article 28.
If it's a zoning bill, we should be able to hold it.
Yep, zoning bill. Zoning
Mr.
bill.
Chairman, if it's a zoning bill, and we believe it is, I think, is the consensus that we're coming up with right now, then
Amend subtitle
this is the last
27.
day to act on that.
Amend subtitle
Because
27.
November, after the election, there's a suspension of all zoning activity until after the new council is sworn in.
Well, I tried. Got to vote.
It's the consensus.
In that case, I say move favorably.
We have a motion and a second. Any discussion? I'll just say I'm extremely troubled with this bill and the way it's arisen. And I would urge folks not to support this at this time. On the one hand, it creates a significant policy shift. While it's interesting to try to accommodate some of the critical area commission's thoughts, the current provision creates an inviolable buffer area. What this proposes to do is create, quote, waterfront lots with a 300-foot setback, which creates exactly the kind of problems that Mr. Dean has said we don't want to have in the future with regard to woodland conservation, because they're not readily enforced. And when people own these lots, they think they own these lots, and that's the end of it. And you can just see the problems that this is going to create. Apart from that, I'm troubled with how we got here. I'm troubled with some of the representation that's been made about what this bill does and doesn't do. I mean, essentially, this body approved the project one way. It ended up changing to something else in a way that I think is questionable. And then we have lawyers down here trying to sell something that just isn't true. I mean, I think I've got some real issues with how this has been brought to us and what's been said. Now, what's happened is we backed out the piece that deals with 2 properties. So this is not just about 2 properties. But what's going to happen is as soon as we put this through, those folks are going to be back to get amendments to their zoning decisions to get to do a circumvention. And this is about as unfortunate a land use action as I can see. And I hate to have to say that, and I hate to be in disagreement with my friend Mr. Knotts. And I know he's looking at this in a positive way, and I don't wish to be in disagreement with him. But I think from the way this has been handled by some of the folks and the policy change that it creates, that we are now going to be having waterfront lots on Patuxent, the Anacostia, Potomac, with the problems that are intended with that. I don't see we should be doing this just to the benefit of one developer who's trying to slide through a text amendment. If we're not going to turn down this one, I don't know which one we're going to turn down. I'm sorry. Anybody else, Mr. Harrington?
Thank you, Mr. Chairman. And I want to say that I respect Mr. Knotts. I respect what he's trying to do. And I won't go into that. I think my concern or reservation around this has to do with that we're still not clear on stormwater management policy and how it affects setback issues, particularly waterfront issues. And we still don't have a consistent we're having some serious degradation on, I know the Anacostia River, and on the Patuxent. But what this seems to do in a policy way is put in front any sort of stormwater management issues that are supposed to prevent those issues in front of then setback issues, which may or may not deal with soil degradation that then compromises then rivers' ability to sort of be a viable river. So I'm concerned about that from an environmental point of view, and I'm not sure that we have set up sort of a map amendment strategy, or how this deals with our green effect sectional map amendments. So I think this is premature until we sort of begin to answer other questions in development prior to doing this. It seems to me that this puts the cart before the horse in terms of a policy objective. While I understand what Mr. Knotts is trying to do, and I'm not opposed to waterfront property, I think you have to put in some safeguards that then protects and preserves our beachheads, if you will, from any sort of degradation. And I'm not sure that we have those protections in place. That this might cause an acceleration of that. Thank you, Mr. Chairman.
Mr. Dean?
Thank you, Mr. Chairman, and I do apologize because I don't have the number of the bill before me, but the piece of legislation that you referenced that I passed on conservation easements, the bill was very specific that before a contract is let, the purchaser must be advised that there is a conservation easement on the property, and that they are told basically what they can and cannot do to the property. The bill came about as a result of property owners not being advised by their agent that there was a conservation easement, and so therefore this bill rectified that situation. So I just want to be clear, because my bill was kind of put into this discussion, that that was the purpose of the bill.
Thank
Thank
you,
you.
Mr. Dean. Anyone else? Madam Clerk, please call the roll.
Mr. Chairman,
No?
Ms. Lane, Mr. Campos,
No.
Mr. Dean,
Yes.
Ms. Exum,
No.
Mr. Harrington.
No.
Mr. Hendershot, Mr. Knotts, motion fails 5-3, 3-5, pardon me.
Okay.
Okay. Next, we have